Recently, Ripple was accused of raising more than $1.3 billion through an unregistered offering of digital asset securities. The crux of the lawsuit involves whether Ripple's token XRP is a security under the federal securities laws. The XRP lawsuit is not over yet. While there were some biggest decisions that were made just this week regarding the lawsuit, but what are those decisions? And what would be their impact on XRP? Join us in today's video to find out about the latest updates about XRP lawsuit and other XRP news. But before we get to it, welcome back everyone to Crypto Millionaires, a channel where you get your daily dose of XRP. If you like the content, do give it a thumbs up. And don't forget to subscribe to the channel and click the bell icon so you can know every time we upload a new video. Now without any further wait, let's get to the video. The company is embroiled in a lawsuit filed in 2020 in which the agency accused Ripple of raising $1.3 billion in unregistered digital asset securities by issuing XRP tokens. The SEC's key claim is that XRP is not a currency, but a security, and therefore subject to strict securities laws. Ripple has argued that XRP is a virtual currency, not an investment contract. The SEC continues, in my judgment, to drag its feet. It just feels like there's a certain hypocrisy since the SEC is continuing to note that justice delayed is justice denied, but they're seeking delays all the time. What Ripple seeks is clarity and a level playing field. The United States government and the regulators of the United States government should not be picking winners and picking losers. The SEC declared war on Ripple. Is Ripple being combative? We're trying to defend ourselves. If you read their initial lawsuit, there's all kinds of allegations there that aren't actually grounded in fact. They've certainly contoured the facts into telling a story which doesn't represent reality, CEO of Ripple stated. Now Ripple and the individual defendants, Brad Garlinghouse and Chris Larson, have filed a letter in opposition to the SEC's motion for partial reconsideration and clarification in regard to the court's DPP ruling. Earlier this month, the plaintiff filed the much-expected motion seeking the judge to overturn her own decision of ordering the SEC to hand over drafts, notes, and emails about Hinman's 2018 speech, which was found not to be protected by deliberative process privilege because the SEC said the speech was only his personal opinion. So the SEC is arguing the speech was public guidance. Ripple's counsel responded by calling the SEC's motion an inappropriate attempt at a do-over simply because it's unhappy with the court's order on its prior briefing. The SEC makes no pretense that the demanding standard for reconsideration is satisfied here. Instead, it seeks to yet again brief an issue that has been extensively litigated for nearly a year, but this time based on a new theory, in a reversal of course. Ignoring its prior briefing and a sworn declaration it procured from former Director of Corporation Finance William Hinman, in which the SEC maintained that Mr. Hinman's speech simply expressed the personal views of the speaker, a position the SEC now knows cannot support its privilege claim. The SEC now argues for the first time that the speech was the culmination of and reflected a policy process within the Division of Corporation Finance. This reversal contradicts Mr. Hinman's sworn statement. Likewise, with neither permission nor apology, the SEC submits a brand new 5-page declaration, in blatant violation of the local rules, from someone who has no first-hand knowledge of the matters attested to. And for all its tactics, the SEC ultimately fails to establish that this court's January 13, 2020 order was an error. The SEC cannot show that the court overlooked any factual matters before it. The court considered and credited both Mr. Hinman's sworn statements and the SEC's representations that the speech expressed Mr. Hinman's personal views. Moreover, the court already recognized that SEC staff were involved in discussions around the speech and determined that those discussions were merely peripheral to actual policy making. Additional discussion, presumably contained within the SEC's self-selected documents, does not alter the analysis. The DPP still would not attach because those communications were not an essential link in a specific consultative process. At most, given that the decisions apparently all concern what should be said in the speech itself, they were merely peripheral to actual policy formation. Finally, the SEC's protein approach to litigating this issue only underscores why the speech drafts and related communications are important and highly relevant for purposes of discovery, to which defendants are in any event entitled. John Deaton, the attorney representing 65,000 XRP holders in the SEC v. Ripple lawsuit, after having been granted amicus curiae status, has previously explained why Judge Netburn's decision on the motion for reconsideration will be the biggest decision in the Ripple case. In regard to the brief, Deaton said, Ripple lawyers are professional and very tactful in explaining that if the court were to accept the SEC's new theory regarding the speech, that it's the division's opinion, not Hinman's, then the court must accept that Hinman lied under oath. Jeremy Hogan, partner at the Hogan & Hogan law firm, has commented on Ripple's reply to the SEC's motion first by expressing the well-written brief that dismantles the many contradictions made by the SEC in regards to Hinman's speech. Wow, I expected Ripple to come out swinging, and this brief did not disappoint. This is the hardest-hitting brief thus far in the litigation, and rightfully so. The SEC has spun itself a tangled web here, and I don't expect the judge to help them out of it. There is no dispute that Ripple sought advice in 2012 from an as-yet unidentified global law firm in 2012, as the company contemplated the launch of a new digital token, nor that the law firm submitted 2 memos to Ripple analyzing the legal issues that could arise from the launch. But Ripple and the government have offered widely divergent accounts of exactly what Ripple's outside counsel said in the 2 memos, which have been docketed only under seal. The SEC contends that the documents show that Ripple and its then CEO Christian Larson were well aware of the risk that XRP would be deemed a security under federal law, but Ripple and Larson, who is now Ripple's chairman, say regulators are mischaracterizing the memos. They said the documents show that Ripple's lawyers ultimately concluded its tokens were not securities. The memos, in other words, are sure to be key evidence in a case that is widely considered to be a critical test of the SEC's ability to regulate cryptocurrency offerings through enforcement actions. And now, thanks to a ruling recently from U.S. District Judge Annalisa Torres of Manhattan, we don't have to rely on either side's description of the advice Ripple received from its outside counsel in those 2012 memos. Torres held that the legal advice in the 2 memos must be unsealed and released publicly by February 17th. That is not what Ripple or Larson wanted. Both argued in the letter motions to Torres that the memos should remain under seal. Larson counsel Martin Flemmenblom of Paul Weiss, Rifkin, Watton, and Garrison told the judge that the memos reflect the proprietary internal business strategies, analysis, impressions, and concerns of a private company and its founder, and that there was no good reason for the public to see them. Ripple argued in a better brief from Michael Kellogg of Kellogg, Hansen, Todd, Fiegel, and Frederick that the documents contain competitively sensitive information and are not actually material to the case. Torres, however, pointed out that even Ripple and Larson have made an issue of the memos in their filings. Ripple's answers to the SEC's complaint, for instance, asserted that a reasonable reader of the advice it received from its lawyers actually would have concluded that XRP was not a security. Larson, who attached the memos as sealed exhibits to his motion to dismiss the SEC case, similarly argued that the 2012 documents never said XRP were investment contracts or securities. Interestingly, as the SEC noted in its brief arguing the judge to unseal the 2012 memos, Ripple and Larson did not press arguments in their seal motions that the memos were privileged. As I've reported, the company claimed in an early status report in the SEC litigation that the memos were shielded by privilege, even though they had been disclosed to third parties in 2013. The SEC told Torres that those disclosures were quite extensive. Larson and another Ripple executive circulated the legal advice to third parties on at least 19 occasions, so Ripple had waived any potential privilege claim. The SEC's crypto regulation could be hobbled if Ripple's fair notice defense succeeds. Right now, because of the extensive redactions in the publicly filed version of its memo to Strike, it's impossible to see why the Commission believes the 2012 memos from Ripple's lawyers undercut the company's claim of inadequate notice. That brief and many other filings discussing the memos will be refiled with fewer redactions next week, according to Torres' unsealed order. That should give everyone following this case a better idea of the significance of those 2012 memos. So this is it for today's video. I hope it could be a great help to you. What do you think about the major decisions that were made earlier? Share your views in the comment section below. Don't forget to click the bell icon, and thanks for watching.